So just to start by introducing the firms, I think everybody knows Cyril, Amarchand, Mangaldas, and it's a 100-year-old legacy firm, and it's the largest law firm in India with over 700 lawyers, including 131 partners across 6 offices in India. CAM is a full-service firm with a range of expertise with strong practices in general corporate, capital markets, disputes, and banking. CMS Cameron Mckenna has been ranked as one of the top 10 global law firms in the world. CMS has 75 offices across 43 countries with over 4,800 lawyers. CMS offers business-focused advice across multiple jurisdictions. Moving on to the panelists, Ram Govind Kurupat is an M&A partner with CAM with over 13 years of experience, having done work on significant M&A transactions across a range of sectors, including pharma and financial services. He also has a keen interest in studying the consequences of pandemics. Jyoti Dastidar is a disputes partner with CAM with over 10 years of experience. She has significant experience in arbitration, original civil trial work, and white-collar crime. CMS panelists include Bill Carr, who is a London-based corporate partner focusing mainly on transactions in the infrastructure and energy sectors. He advises on a range of private transactions, including M&A, joint ventures, corporate governance, and restructuring of a cross-border nature. Bill co-heads the CMS India desk in the UK with Alistair Steele and is a regular visitor to India. Alistair Steele is a corporate partner and head of CMS's ECM practice based in London, advising on a range of public and private M&A transactions, as well as cross-border IPOs and secondary fundraisings in the capital markets. Alistair co-heads the CMS India desk along with Bill and has been a regular visitor to India. Simon Kilgore is a partner in the CMS Insurance and Reinsurance Group, who specializes in complex coverage and catastrophe claims, including the current COVID-19 crisis. Simon acts for many international reinsurers, including Indian state companies. Stephen Cochran is an employment partner based in London, and his practice includes advising clients across a range of sectors on their strategic people issues. Stephen has been heavily involved in advising clients on their legal obligations towards employees and on the new coronavirus job retention scheme announced by the UK government to mitigate the current economic crisis. Let me start the panel discussion now, starting with Simon. Simon, I think the main question on everybody's mind today would be performance of contracts and how that is to be managed. We've seen many instances of how the obscure force majeure clause in contracts have been used to shore up one's resources and by non-payment at this critical juncture. What are the trends you're seeing in this space, and how does the company respond to that situation? Thank you, Simon.
Thank you, Alice, and good afternoon, everyone. I hope you can hear me from here in London. Quite a few issues there, Alice. I mean, at the moment, it's a bit early for there to be major disputes about supply chain contracts. People are, obviously, though, everyone is considering, how do I need to survive? How do I need to renegotiate my commercial contracts? And obviously, what rights do I have in those contracts to do so? Against that, also, there is the backdrop of government aid, and how does government aid fit into the equation? The lawyers can't provide all the answers, and it's all very well having some legal rights and the ability to make a claim in several months or a few years' time, but obviously in the short term, people are trying to survive, and therefore, ultimately, what we are seeing is a lot of people having to renegotiate contracts, because the law, whether it's insurance law or it's principles of force majeure, they expect the parties to mitigate their losses, and in that concept of mitigation, that means that they should be picking up the telephone, emailing, and see what they can do to renegotiate and mitigate the losses they may face. Obviously, though, in the current crisis, which undoubtedly is unprecedented in terms of its global effect, a simultaneous global effect, there will be a fundamental problem for the performance of many contracts, and it may be appropriate for those contracts either to be suspended, the obligations to be suspended, which is where force majeure comes in, which I'll kick in. But sometimes it may be impossible for those obligations to be performed, in which case you're looking at termination of the contract. So in all of this, you have to work out, is however long this lockdown goes on for, is it something where my obligations are going to be suspended, or is it impossible for me to terminate the contract? So we are seeing things like, pop concerts, events, Olympic Games, a lot of these things are insured, of course, they're being cancelled because they just can't happen. So cancellation and a legal frustration of contract is something different to force majeure. Now, force majeure is a legal concept. Some of you may know it floats in the air. It's a different principle in different jurisdictions. It's French, force majeure. That's where it comes from. It's a fundamental principle of French law. It's also a principle of Russian law. Places like Spain, it's a principle of. Places like Luxembourg, Belgium, but not everywhere in Europe. Not in Italy, not in Germany. And there are different principles. The principles there really are more about frustration of the contract. In the UK, which Indian law is a very similar common law system, it's not a principle of English law. So force majeure is ultimately, as far as English law is concerned, a creature of the contract. And you have to look at what the contract says. If the contract allows you to regard a pandemic as a force majeure event, then you can declare it as such. If it's not, then you may find it more difficult, because how these things work is you have to serve a notice on the other party and say, can I suspend my obligations? If the other party doesn't accept, then you have a dispute. And obviously that's what people want to try and avoid. So really, it depends on the nature of the contract. It depends on the jurisdiction. It will depend on the governing law. And it will depend on the performance of those obligations. Can they be suspended or can they be terminated? But behind all of this, all the parties have a duty to mitigate their losses. And that's probably the shortest summary I can give you, Alice.
Thank you. Thank you, Simon, for that insight. Ram, I would like to ask you about where do you see maximum disruption in India? Is it foreign investment, trade, movement of goods and services? Your thoughts on that?
Yes, thanks, Alice. I think, firstly, it's upon us to acknowledge the fact that this is a significant humanitarian crisis, and one that we hope will be resolved sooner rather than later. But if we move from there to the economic consequences of this, it's a major black swan event, and that has really affected the ability of people to cooperate with each other and has a significant business impact and related to recessionary trends. It principally affects the ability of people to move across borders, and consequently even the ability of goods to move across borders. Now, that may be state borders, it may be international borders.
Ram, I think we lost you a bit over there.
Am I audible? Sorry, I cut out, I think.
Yeah, please continue.
Yeah, okay. So we're seeing closure of borders and cancellation of visas. So increasingly, India has been a beneficiary of globalization and foreign investment. And the moment borders are closed, whether it is for people or goods and services, this has an impact on subsequent investments that were likely to flow. MNCs, private equity funds, etc., are also going to increasingly be inward-looking and looking to shore up cash and resources, as opposed to being expansionary. And potential investments or something that they may have lined up is likely to get hit. So that's, I would think, the first consequence. The second is more sectoral in nature. Now, there are certain sectors which are impacted more than others, and we're seeing that already. Things like aviation, tourism, hotels, even construction and real estate for that matter. However, it's not all doom and gloom. There are certain services and sectors which seem to be doing well notwithstanding, and also given the peculiar nature of the crisis. This includes web services, telecommuting, pharmaceuticals, healthcare, FMCG, insurance. So these are some sectors where there is likely to be uptick, but it all remains to be seen as to whether this crisis deepens or gets resolved. There are also certain areas of work which are likely to see an uptick, and that would be things like stressed M&A and bankruptcy-related matters. But these are obviously not positive impacts that we would like to see, but that's where we find ourselves. Back to you, Alice.
Thank you. Yeah, thank you, Ram, for that. Alistair, I think people are all focused on shoring up their businesses. what are some of the indirect issues that should be of concern to a corporate in the context of this unprecedented crisis? Compliance, governance, audit. Your thoughts on that? What focus should be given to these items?
Thanks, Alice. I think there's a number of things that people need to be thinking about, and a lot of it's not particularly obvious until you do apply your minds to it. So I think if you look at a typical manufacturing business, at the moment, everyone's probably sitting there thinking, well, we've got a shutdown, we can't manufacture, we're not going to get going again. But when the business starts to think about what the future looks like, then it's not just how long is it going to take me to get my employees back to work and get my plant up and running again. You've also got to start thinking about your own supply chain, and it goes all the way down. So because of the way the lockdowns have come in, it's been very much standstill for people, and there will be stocks and inventory of goods there. So a lot of businesses will be able to start getting up and running very quickly. The challenge for them is going to be that at some point they're going to need new stocks in, and what's the status of their suppliers. So I may be fine, I may be able to get my factory back up and running, but the person who supplies me with parts, or the person who supplies my part supplier further down the chain, they may be out of action, and they may be running behind. So that the immediate effect on the business may be very little, but in a month's time it could be much more serious. So I think people need to sort of look further down the line and look at the entire supply chain. Other things that are sort of more immediate, and indirect. You touched on governance, Alice. I mean, that's one of the tough areas, and even for any company that's operating internationally, or even from different places, you've got a chain of command. There's supervision and control, and a lot of the time that will involve people moving around from one place to another and making sure things are happening. That's not going to be happening. So there are risks to businesses as to what exactly is happening in your subsidiary operations elsewhere. That's flowing directly into things like audit and completion of annual accounts. There's two parts to the audit process, which are real issues at the moment. How do you actually conduct the audit process? How do you go and physically check stock and check records if you can't visit the company's place of business? And then the other thing that the accountants are really struggling with at the moment is whether they can sign off on going concern status for companies, given the huge uncertainty in the world at large. And we've heard anecdotally that some of the big accounting firms have a 2-week moratorium at the moment. They will not sign off on any audit opinions. Other things that people need to think about, if you're regulated in any way, if you have filings or notifications to make to authorities, how is that going to happen? How can you get to the point where you're satisfied that you can give whatever declarations needed? If you're a company with a number of shareholders, if you need to hold a general meeting, either to get an authority to do something or just your annual general meeting, and the AGM season is pretty much now in the UK for a lot of companies, when there are bans on people getting together in more than two people, how do you hold an AGM? And is there anything you desperately need approval for, that you need a shareholder meeting? How do you deal with that? So these are some of the indirect things that people need to start thinking about, and we're seeing coming through, and more people starting to address workarounds.
Thank you, Alistair. Ram, in the Indian M&A context, what clauses are you seeing coming into play in light of this crisis? Are parties backing off from their transaction documents? And if so, under what provisions are they doing so? Can you just throw light on what could potentially be the consequence of this in transactions?
Sure, Alice, thanks for that. First off, I think we need to acknowledge the fact that in M&A transactions, the going-in position is that both the buyer and the seller, when they entered into the transaction documents, wanted to do the deal, and they still want to. The issue that is really being faced right now is that the month of January saw the Indian stock market at its all-time high. So it is possible that an acquirer may feel that he is significantly overpaying for an asset or for shares than what the market currently demands. The second point is obviously the market contraction that has happened on account of the current crisis. As a result, acquirers are seeking to place reliance on clauses such as material adverse change or material adverse effect, or as Simon had pointed out earlier, provisions relating to impossibility of performance of force majeure. Now, that being the case, the manner in which MAC clauses are applied would vary from contract to contract, because there is the usual MAC clause which is linked to events which have a detrimental impact on the business or make the contract impossible to perform. But there is the exclusion or the carve-out into which you typically build in situations such as pandemics and acts of God. So in a scenario where a pandemic is an exclusion to a MAC, it is not possible for an acquirer to walk away from that transaction. However, there is another way in which these clauses are now being used. That is where the MAC is linked to financial metrics or EBITDA linked conditions. Now, on account of the market contraction and fall in demand, and particularly in certain sectors, for instance, let's say aviation or hotels, these metrics would not be fulfilled. And as a result of this, it is possible to actually invoke this MAC. Now, in a circumstance where the MAC cannot be invoked, parties may look, or the acquirer may look, to rely on the principles of frustration of contract, which is what you have in Section 56 of the Contract Act, and the related impossibility of performance. And to this, the argument always is that there are certain conditions such as CPs which are impossible to perform in a lockdown scenario, whether it is operational consent, consent from third parties, lender consent, etc. Another, and if these conditions are met, or if the financial metrics don't make sense anymore, acquirers may also look to adjust the consideration. But this all depends on whether the contract actually builds in this flexibility. Lastly, if the acquisition was in any means leveraged, or they were looking to raise funds for the acquisition, because of the market contraction and the fact that now cash is king, there is less of an appetite to deploy cash, and lenders may also not want to be lending in this cross scenario. The ability of the acquirer to actually obtain funds to do the transaction may be hit. So these are some of the clauses and some of the impacts that we're seeing. Back to you, Alice.
Thank you, Ram. We are potentially looking at a massive disruption in the job market. I think many people are concerned about how this will pan out. And my question is to both CAM and CMS about what are some of the measures that the governments in your respective jurisdictions have initiated with respect to employee relief?
Thank you, Alice. Sorry, what I was saying was, I think what we're seeing is that across Europe, governments are deploying a mixture of different measures, similar but different measures, to support employers across all sectors, really. And really what this has included so far, a variety of things like tax moratoriums, payment extensions on things like social charges. A big theme has been wage subsidies for staff who cannot work, perhaps because of the lockdown or because they are in self-isolation. And then also financial incentives for employers to keep employees on the payroll and to avoid redundancies, in order to keep people spending and keep the economy propped up. So what I thought would be helpful to do, many of us are quarantined, there's a travel ban in place, so I thought it'd be nice to go on a bit of a virtual road trip across Europe and just touch very briefly on some of the regimes in the various different countries. So I'll start off with France, and in France, the French government has extended its existing system for partial unemployment. So when a company is forced to reduce or to suspend work, the employer can now apply for state funding of 70% of an employee's gross salary, and that's capped at a maximum of just under €7,000 per month. Looking at Germany, the government there has expanded its short time allowance. That's an existing regime, so they have expanded that now to expressly include companies that are cutting working hours as a result of the coronavirus, and at the same time level up unemployment benefits again to just under €7,000 per month. So looking at the United Kingdom, I'm most familiar with this regime because I'm based in London. Our government, similarly, we have some state aid for employers. The main focus has been on employees under what's called the Coronavirus Job Retention Scheme. So that's basically a mechanism whereby employers can apply for a government-funded grant to cover 80% of employees' salaries up to a maximum of £2,500. So that's around about €2,700 per month. I think when the scheme was announced, it's fair to say it was very much applauded. It was received very positively, but there was a perceived lacuna in terms of the 5 million self-employed workers that we have in the UK, because they were not covered by that scheme because they were not employees. So this gap has now been closed, with the UK government subsequently announcing a similar scheme for self-employed workers. Looking at Ireland, a new temporary wage subsidy has been introduced to allow companies to recoup up to 70% of salaries, and that's up to a maximum of €410 per week, or around about €1,800 per month. And special arrangements have been made for particular sectors such as the healthcare sector and the childcare sector. And then looking at, I won't cover off Spain and Italy because their systems are broadly comparable to what we've seen in the UK, but saving the best for last, unsurprisingly, perhaps the Nordic countries are really the gold standard in state aid for employees. And perhaps the most far-reaching scheme that we have seen in recent days is in Sweden, where the government there has said that they will heavily subsidise workers' salaries so that employees will still receive 90%, that's 90% without a cap of their pay whilst working reduced hours. And alongside this, businesses have been allowed to defer tax payments for up to a year. And that has been, as you might expect, extremely expensive. I think the figures that I've read it's something equivalent to 6% of GDP. And then Denmark similarly has announced measures saying that it will subsidise 75% of salaries for any firms promising not to lay off staff. So I think I'll just wrap up. I'm conscious of time, but I think in addition to these direct financial assistance measures, the governments across Europe are also looking at secondary measures. So, for example, in the UK, where we generally have a use it or lose it policy in relation to annual leave or vacation leave, you have to use it in the current year or you lose it. The government is very cognizant that some people will be unable to take holidays or unwilling to take holidays because they cannot go anywhere. So legislation has been passed to allow employees to carry forward their annual leave entitlement until 2022. And then some other measures, deadlines have been extended for, filing, compliance with the Equality Act issues. So, for example, the gender pay gap reporting disclosures in the UK have been suspended for this year, and the employment tribunals, the labour courts, are either postponing dates or they're giving parties longer to comply with directions, or indeed leveraging technology by having virtual hearings where that's possible. So I think in a nutshell, a broad spectrum of measures have been put in place.
Thank you, Stephen. Ram, quickly, if you could just provide insight on what the Indian government has done.
Yeah, thanks, Alice. I think a lot of what Stephen has said is quite instructive, and these are probably things that the Indian government needs to take note of in designing its measures. As it stands today, it's a fast developing scenario, and the measures that have been taken as on date are not significant. As and when the new challenges are thrown up and as the situation develops, some solutions are being provided by the government. So there are some positive statements that have been made by the Prime Minister and the Finance Minister in relation to continuing to pay employees during this period, do not retrench. There is a scheme that at least 28 days paid leave should be given to those individuals who are either infected or quarantined. And some state governments have issued guidelines that employees should be paid notwithstanding the lockdown and absence in attendance on account of the social distancing measures. But having said that, as it stands today, there are no subsidies or grants that have been offered by the government to either employees or employers, or minimum guaranteed pay, etc. So we'll have to see. Probably we'll take some learnings from what Stephen has said is happening in other jurisdictions. Thanks, Alice. Back to you.
Thank you, Ram. Stephen, then this brings me to the question about how does an organization manage their employee relations, and from a perspective of how to get their management decisions right. What are some of the decisions or the steps that an organization should undertake to handle their employee-related issues given this crisis? And what are you seeing in Europe currently?
Thank you, Alice. So yeah, I mean, I think it's a really interesting question, but I think it's a difficult one because obviously this is, very much new territory for all employers. So for this question, I'm going to focus on, I guess, the softer, perhaps the non-legal side of what employers are having to consider, rather than specific legislation. The themes here are really very general and applicable to all employers across Europe. In fact, the differences in approach that we are seeing are likely to be more pronounced from one sector to another, rather than as between particular countries. So I'll touch on general themes and trends rather than going through particular jurisdictions. I think one thing to say, first off, from an employee relations and employee engagement perspective, is that many organisations are already cognizant of the reputational risk around their HR strategy and their crisis management. I mean, I think it's fair to say when this crisis is over, and it will be over at some point, it might not feel like that at the moment, when this crisis is over, people will reflect on how their employer has handled things, and how flexible they were, and how good communications were. And I think those employers who manage the process well will reap the rewards in terms of goodwill, whereas the opposite is true of employers who are less paternalistic and do not get things right. And I think on a similar note, those employers are also conscious of their external PR. And I think this is particularly true of big name blue chip organisations. I think they too recognise that a poor HR strategy could result in long-term reputational damage within the market, and that in turn will damage their recruitment and retention. In fact, I was just yesterday made aware of a website that has been set up, and it's www.didtheyhelp.com, and this has been set up to name and shame, or commend, as the case may be, big employers and also celebrities who have responded particularly well or particularly poorly to the crisis. So that being said, what does good look like? Well, I think in the interest of time, I'll just touch on a few golden rules. Some of these are cost neutral; they don't cost anything. They're really just common sense. So I think they're easy wins for employers. So I think the first thing is good communication. Goes without saying, people are anxious. People are being bombarded daily with news on their iPhones and their Apple Watches. So it's really important for employers to be mindful of that and the psychological impact of that. And I think particularly when a large proportion of the workforce are working from home and not having face-to-face contact with colleagues, HR should be maintaining FAQs, Q&As on their intranet. Leaders should be sending out regular updates on the situation and how it's being managed, and where possible doing this by conference call or WebEx rather than just sending out emails. I think secondly, being creative around flexible working. This is obviously key given the severe restrictions on people being able to travel. Lots of people are working from home overnight. People are working from home on a full-time basis. And I think employers need to remember that working from home affects employees differently depending on their own responsibilities and circumstances. For example, here in the UK, in fact, in most countries, we've seen widespread school closures, and a number of employees, myself included, are trying to balance working from home with having young children. So my wife and I have a 6-month-old baby and two children to try to homeschool, and we're having to fit that in, amongst our work responsibilities. So I think employers need to be flexible in terms of allowing their staff to, to balance those competing interests. I think investing in tech and using the tech that employers already have to the best of its ability, home working and additional flexibility comes with technical challenges. And my experience over the past few weeks has certainly been that the clients who have adapted to this new normal best are the ones who already had infrastructure in place. And it's not just about bandwidth, and it's not just about VPN. Not all employees will have an appropriate workspace. They might not have a home office, they may not have a monitor or facilities to print and scan. So some employers are contributing towards employees purchasing the necessary tools. But of course, this will not always be possible. It may be cost prohibitive, but it will always be necessary to have an eye on health and safety, taking steps to ensure that employees have a safe working environment, and that employers allow adjustments or accommodations for employees who find their home setup slows things down or makes things more difficult. And the last thing I'm going to touch on, and this is probably the most important one actually, is to be mindful of the effects of isolation on well-being. I think for workers who have never worked from home, social isolation will be really, really deeply felt, particularly for people who live on their own. And it's very, very hard to replicate daily interactions with co-workers. So, those chats that you have in the staff canteen or going out for coffee or having after-work drinks, those things have just stopped overnight. And human beings, we're social animals, and that reciprocal supportive interactions with work colleagues really, really promotes social well-being. So companies should not assume that this will happen naturally and should be encouraging their employees to have virtual coffees, virtual lunches, using Skype, using Microsoft Teams, so that employees have those touch points and have that face-to-face time. But one thing I would say there is be respectful and bear in mind that not all employees like to do things by video. So, it's a case of, being open to change and being flexible, but not enforcing 5 p.m. Friday virtual drinks on all employees, because actually for some people that just will not work for them.
Thank you, Stephen. I think that's a very important point of, not all people are attuned towards online working. Just to move on to the next question, Ram, some of the lessons that you would think people should take away from this crisis, particularly in terms of which clauses would you say they should now focus on while entering into documents, and particularly how to negotiate it if you were to look at it from both sides? Some tips on how you would want organizations to review their contracts before signing.
Thanks, Alice. I'm going to focus here on M&A transactions. That's my stock in trade. If we look at this question from a seller standpoint as well as from a purchaser standpoint, the seller's focus is often on deal certainty. So a seller would always want a binding contract with no real escape route. But at this point in time, what purchasers really want is flexibility to account for the situation on the ground. Now, that being the case, we're going to see a lot of focus on objective business-related metrics, which will impact the ability to both close the transaction as well as adjust consideration. So that's the first aspect. So any clause that you have in relation to MAC, etc., will now have proper objective criteria. If it is, let's say, 25% loss of business, then you look at an adjustment. If it's 50% or more, then you look at a walk away. So you'll have these objective metrics built in. Parties will also need to be very flexible about operational matters such as standstill provisions, long stop date and the extension of the long stop date, flexibility in relation to how CPs are fulfilled, regulatory approvals and the amount of time that it takes to get those approvals, particularly when you're operating within the lockdown, how the closing is actually going to be achieved when people can't physically interact. So these are things that will now, come into focus, and we'll have to start building in these sort of fail-safes into contracts. Back to you, Alice.
Now, I'd like to move on to the next question and the important aspect of how the judiciary will review these contracts and crisis, management issues. Simon, my question to you, given your experience in insurance sector, is how are the courts likely to respond to this crisis, particularly in terms of insurance contracts or clauses and the SM clauses? Any thoughts on how you see that going forward?
Thanks, Alice. That's a very good question. One of the things we are seeing as a major issue at the moment is loss of profits in insurance contracts. In the property insurance space, commercial property will normally have as an adjunct a business interruption policy, which is intended to pay losses where there's an interruption of business. But for whatever reason, those policies don't deal squarely with the current situation we face ourselves in, where there is a pandemic. So we're seeing a lot of variation in the response of insurers to the current crisis, where clients want to be able to say they've got a loss of profits caused by a crisis, pandemic, but where there hasn't actually been traditional property damage, physical damage under the policy. And the insurers are taking an old-fashioned view at the moment, saying, well, if you haven't got property damage, I'm afraid you can't recover loss of profits. So much depends on the definition and the words of the individual contracts. We're seeing a big issue as well sitting behind that, which is where you have landlord and tenant. There's a moral obligation on landlords to try to forgive or at least give rent holidays. But what they're worried about doing is prejudicing the position under their insurance contract if they forgive rent. So there's a difficult tension at the moment between people trying to do the right thing as landlord and tenant, and also trying to maximize their insurance recoveries. So I think the insurance losses are going to be a lot worse than people think, and there's a lot of political pressure building up. So watch this space is what I'd say, Alice.
Thank you. Thank you, Simon. Jyoti, from an Indian legal landscape, how are you seeing our courts responding to this crisis? And I think most of the listeners would like to know what they should keep in mind when it comes to contract enforcement. What are some of the suggestions that you would have for them to be ready for a dispute situation or any kind of court processes that they might have to embark on given this crisis?
Thank you, Alice. For litigators like us, the COVID-19 pandemic has been a major disruptor as far as court practice is concerned. However, Indian courts, especially the Supreme Court of India, have responded very quickly to ensure that parties' access to judicial processes are seamless and uninterrupted. Several practice directions have been issued in the last few weeks. We wanted to highlight that first, courts are functioning and hearing urgent matters, albeit in a limited capacity. Matters, however, which are being heard as urgent over the last few days are those which involve a public interest element, or petitions seeking emergency directions due to COVID, or even urgent bail applications. It's important to know that in the current scenario, commercial disputes are not being seen as urgent matters. Costs are also being imposed upon parties by courts for listing of non-urgent matters. This situation is still developing, Alice, and we can expect more practice directions in the immediate future. Second, with respect to limitation for filing appeals to a higher forum, we have seen that the Supreme Court has extended this period. What this effectively means is that if the last date for filing of an appeal ended during the lockdown period, your appeal will not be treated as time-barred. We do, however, recommend that you keep the petition or appeal ready for filing and file it on the date to be announced by the Supreme Court as the end of the lockdown. Alice, with respect to the second part of your query, from a contract enforcement perspective, we should keep 4 key aspects in mind. One is, of course, whether the present scenario is a force majeure event and whether force majeure has been correctly invoked is a fact-specific determination. We therefore recommend that all key contracts should be analyzed to assess the parties' rights and obligations, especially with regard to 4 clauses: determination, the force majeure, governing law, and dispute resolution. Second, if you are disputing the counterparty's invocation of the force majeure clause, we would recommend that you obtain strategic and legal advice on the communications to be sent out. This also ties in with the third point, which is that we recommend that you carry out a detailed review of your supply chain to understand the geographic scope of your operations, your dependencies, your business risks, and legal rights. Fourth, it is also important to assess the remedies that are available to you under the contract, whether there's an arbitration clause or whether you have to approach the courts for specific performance. Other points to be considered are your services essential services? Does your contract contemplate a temporary stoppage of work? Do you have a take or pay clause? Do you have a clause for adjustment of shortfall quantities in subsequent years? But the most important takeaway really, Alice, is that parties should make an assessment of their obligations and of the specific terms of the contract. Over to you.
Thank you, Jyoti, for that very insightful analysis. Bill, I would like to call upon your experience and with CMS's network across the globe, where all of us sitting across the globe are facing this one common problem. How different would the world be going forward in terms of contracts and enforcement? I think many people are looking to see how Europe is going to react. Many of the Indian companies having businesses in Europe would be expecting some sort of relief measures or a way forward from governments. What are your thoughts on this, and what should the Indian companies be expecting out of Europe in this time?
Thanks, Alice. I think it's a bit too early to draw any particular conclusions about enforcement. The reason being, at the moment, that varies very much from sector to sector and from country to country. And from a European perspective, the European Union is really playing catch up on how support packages should work and how enforcement ought to be looked at more generally around Europe. So, for example, if you look at the real estate sector, there are a number of countries that have introduced moratoriums on enforcement action on leases, particularly for residential leases. So France and the UK do have moratorium on actions. Other states haven't done that yet. There's a lot of landlords who are looking at what they should be doing about enforcing, particularly where there are rent arrears. Another example is in relation to public sector contracts. There's some jurisdictions, such as France, have declared that the COVID pandemic is a force majeure event for public sector contracts, which means that the contract counterparts, so private sector companies supplying, have relief from their obligations. Then if you look at the banking sector, certainly in the UK, is very, very reluctant to seek to take enforcement action at the moment. So what we're seeing with our clients, both our banking clients and our borrower clients, is that lenders are keen to engage in discussions to understand what the issues are, but are not at all keen to seek to enforce contracts. Most banking facility agreements will have events of default which have been triggered or are about to be triggered by this, such as on filing accounts or on meeting deadlines. And our experience is that lenders are very, very reluctant to take enforcement action. In relation to what Indian clients are asking us at the moment, so one area which is of particular interest is the support packages for employees and process to deal with employees, and I think we've talked about that. The other area which is of particular interest is whether the liquidity support facilities might be available to them. This, as I say, varies very much from country to country, but from a UK perspective, in principle, those support packages should be available. However, the government has recently said that the liquidity support package for large companies will not be available to public sector owned companies. So that may be a relevant consideration for Indian corporates who've got subsidiaries in the UK where the owner is the government of India. The other question we're getting is whether the banks will introduce a general moratorium on taking enforcement action, as has happened in India. And I think the answer to that is probably not. But banks, as I say, at the moment are taking a very pragmatic approach with their lenders. So from that perspective, I think it's key for borrowers to be having early and detailed conversations with their lenders. So I think that's what we're seeing at the moment. I guess the biggest takeaway for me is that governments are really playing catch up at the moment, and things are moving very fast. So it is key for businesses to keep up to date with what the evolving situation from a government perspective is.
Thank you, Bill. I think it's a lot of ground to cover for all of us, isn't it? I think my final question will be addressed to all the panelists. If you had one wish, what would be the top reform you would want governments to undertake? Bill, may I start with you first? What is in your top of the wish list that you have as a government-led reform to tackle this issue?
Well, mine is going to be UK specific, I'm afraid, but I think that's the best thing I can talk about. So there's quite a generous government scheme in for liquidity support for businesses. Lots and lots of businesses are now locked down with no revenue coming. The issue with that support package is how it's being implemented by banks, and banks typically will, before they make the liquidity available, will want the companies to have access different sources of finance, and that's making things very, very difficult for the UK businesses. So I think our government did announce yesterday changes to those packages, but it's from my perspective, it would be key for there to be much more clarity on how this operates, and for the banks to be working much closer with businesses in making support available. So that's my wish list.
Thank you, Bill. Alistair, your wish?
I think from my perspective, it would be governments looking at and implementing much more effective ways of restructuring businesses that are in financial difficulty. I think that Chapter 11 in the US works considerably better than any of the sort of UK or most of the European resolution procedures. So I think it's something, an insolvency process which allows companies to genuinely be restructured, recover, and come back out, rather than what we've got at the moment.
That's a good point. Stephen, from your perspective, what would you come up with for the government to consider?
Thanks, Alice. Well, I mean, I think from a purely selfish perspective, I would like to introduce free babysitting. But I think on a serious note, looking back at the wage subsidy schemes, and in particular in the UK, I talked about the coronavirus job retention scheme. And the way that this has been rolled out in the UK is that it seems to be open to all employers, not just those in distress or not just those with immediate cash flow problems. And the bar has been set really quite low. I mean, the guidance says that you just have to show that you, as an employer, you've been materially impacted by COVID-19. Well, all businesses have been materially impacted. So, I think what would be good is to see some forms of a means-tested system, so that the main beneficiaries of that state aid are those who really, really need it, and those who are, on the brink of insolvency almost. Because at the moment, what we're seeing is a number of, blue chip organisations who have a healthy balance sheet and healthy working capital are accessing the government funding because they want to make prudent financial decisions. And personally, as a taxpayer, I don't think that's quite right. So I would like to see the bar in terms of eligibility raised.
Thank you, Stephen. Simon, your one ask from the government?
Yeah, so I think I'm looking at the insurance perspective. This coronavirus crisis has turned out to be a lot bigger than anyone would have thought, and can be described as a global catastrophe, economic or health-wise. What we've seen before, where there have been other catastrophes, I'm thinking about terrorism after the World Trade Center, is insurers run scared of it. So every single insurance policy moving forward will have some sort of exclusion which will exclude cover for pandemics. which means it's uninsured, but in circumstances where businesses need to mitigate this risk. And what normally happens when you have an uninsured exposure, it can be flood, for instance, or terrorism, is you end up having a government pool which sits behind the insurance industry. So I think what will happen moving forward is society will now have a significant uninsured exposure, and that gap will have to be filled if the domestic insurance companies don't want to fill it. So that's something for the future, but that's something that I can foresee being an issue.
Thank you, Simon. I think that's a very valid point. Jyoti, from a judicial, approach, judiciary approach, what is your ask from the government of India?
Thanks, Alice. We see today that commercial disputes are not being treated as urgent matters as far as Indian courts are concerned. However, where institutional rules such as SIAC or LCIA or ICC permit emergency arbitrations, parties are free to explore that option to safeguard the subject matter of dispute once it arises. But we see that in India, there is no mechanism for enforcement of emergency arbitral awards passed in foreign-seated arbitrations. So my wish list is for the government to address this lacuna by introducing a legislative mechanism for enforcement of foreign-seated emergency awards by Indian courts. Some legislative certainty would go a long way in these times. Over to you.
Thanks. It's a fantastic suggestion. Hope the government hears that. Finally, Ram, with your interest in consequences of pandemics, what are your thoughts on this question? Or what should the government first undertake?
Thanks, Alice. I think the Indian government has been pretty good at a macro level, based on what Bill just mentioned about the moratorium in relation to loans, etc. So these measures have been taken at a macro level. However, beneficial provisions at a micro level are something that need to be taken to really kickstart or continue the movement of the economic engine. And for that, I would think it's universal basic income, which is backstopped by the government. While this may seem like a socialist solution to a capitalist problem, it has far and wide-ranging consequences, because the moment there is this universal basic income, there is the expenditure on essentials, and it's a continuation of the virtuous cycle, as it were, of production and consumption. And this should last for the entirety of this crisis, and maybe 2-3 months hence, as the world gets back on its feet once this crisis abates. Back to you, Alice.
Thank you, Ram. I think this brings us to the conclusion of the panel discussion. We are now opening up the question and answer session, which will be for about 10 minutes. My colleague Ram and I will be taking up the questions. I think the first question I will start out with, and this is addressed to the CMS team. Perhaps, Alistair, you can answer this question. What do you see as the main challenge for raising funds in this market?
Main challenge for raising funds in this market is around the uncertainty. What I'm hearing from both the banking world and the equity world is banks and investors do have cash and they are prepared to invest it, but they are very much focused on looking at their existing investments and supporting those, and they are not particularly open, well, they're not open at all to making new loans to new businesses or making new investments into new investee companies at the moment.
Thank you, Alistair. I think the next question is again, an attendee wants to know are we looking at work from home as the new normal for all of us, and whether that is actually a good thing. So perhaps somebody from CMS and Ram or Jyoti from CAM could answer it one after the other. Bill from CMS, would you like to address whether work from home is now the new normal for us?
I think that well, once the pandemic is over and we're back to some sort of normality, there will have been a big change to how people do work. So there will be much more home working. But I think sort of what none of us want is for everyone to be working in isolation and for social interaction to go away. So I think there will be more of it, but I think there still will be a big place for workers to get together in sort of more of an organized working environment.
Great. Ram, your perspective on whether in India we are likely to see work from home?
Yeah, so a couple of points there. For the longest time, employers have not been too friendly to the idea of work from home. But now that the crisis is upon us, there is a lot of comfort with the fact that people can and do, in fact, work from home. The nanny situation aside. I think the other key point is about what work does. There is the social interaction angle to it, and there's the transactional aspect to it. So while the transactional aspect can be taken care of by working from home, the social aspect also needs to be taken care of about interaction, association, meeting people, etc. So I don't know whether that will be the new norm. It also depends on how long this crisis were to go on. But I think there's a lot more acceptance in India and overseas that this can actually happen, and you don't need a separate space such as the office in order to continue to work.
Thanks, Ram. I've got another question about how technology innovation is likely to accelerate in this scenario. This crisis has probably brought about the importance of technology in all our lives. Any thoughts on how you see that being accelerated pursuant to this crisis? I think perhaps again, anybody from CMS would like to volunteer to answer this question. I would love to hear your thoughts on that. Stephen, Bill, Alistair, one of you could address this question. I think people will start looking much more closely and more effectively at some things. So, particularly around ability to work remotely, working from home. I think we'll see that sort of technology accelerate. I think outside of that, I'm not sure I see this being a particular driver for accelerating developments in that respect. I think it may almost go the other way in terms of people sitting back and taking a look at supply chains and the way they run their business, and the whole manufacturing model of just in time is something I think people will start to be looking at and say, well, maybe I do need to actually carry bigger stocks of inventory and not rely on the supply chain coming through as and when it's required.
Yeah, I mean, I think it's Stephen here. I mean, I think the one thing that I would just add to that, I think, the court system, the tribunals, mediations, arbitrations, I think, there has quite often been a perception that those types of forums just do not lend themselves well to, virtual scenarios. So, parties have been very resistant to that. I think what we've seen over the past few weeks is actually that's not necessarily true. And with the right technology, things can be done remotely, and you can retain that sort of human dynamic if the technology is there. So I think that we'll in the dispute resolution space, I think we will see an increase in the use of technology.
Perfect. Ram, the next question is for you and Jyoti, actually, Jyoti as well. I think one of the attendees would like to ask if, irrespective of having a force majeure clause, am I always protected under Indian contract law? So their question is, if you do not have a force majeure clause in a contract, would I still have protection under the Indian contract law? Just a quick word from both of you.
Jyoti, can you take that first and then I'll step in?
Yeah, sure. So even if there is no force majeure clause, yes, it is possible to take recourse to Section 56 of the Indian Contract Act for impossibility of performance and frustration. So yes, it is possible. You can choose whichever course is open to you. If there is a force majeure clause, great, that comes under Section 32 of the Indian Contract Act. If there isn't, then it will be a case for frustration. Of course, the burden of proof is on the party who is saying that there is there is impossibility of performance.
Yeah, thanks,
Thank
Jyoti.
you.
I think
Ram, anything more?
I think that I concur with Jyoti's view on that, particularly on the point of the availability of the remedy for frustration and impossibility of performance, as well as the burden of proof to establish that such a circumstance actually arose, which should be easy enough to do in the lockdown scenario.
Thanks, Ram. I think one question specifically for the CMS team has come in. It's been in the news that the Chinese government is issuing occurrence of force majeure certificates, irrespective of the presence of such clauses in the agreement. How will such certificates hold relevance in cross-border M&A situation? Any thoughts on that? I think Alistair, Stephen, one of you could perhaps take this up.
So, Simon, do you want to comment on the effect of a Chinese certificate on a force majeure in an overseas contract?
Yeah, well, I think probably primarily to help domestic market in China. Obviously, the Chinese government, as was well reported, issued thousands and thousands of force majeure certificates, which obviously could be relied on nationally, as would be the case in India by analogy, to sort of forgive and allow suspension of supply chain contracts. But I think when you go into the international context, the question is, can you rely on that certificate being recognized? And that then comes to the issue of, if you serve a force majeure notice, will it be accepted by the counterparty? And also, what's the governing law of your contract? Just because your national state says there's an issue of force majeure, that may not help you if you don't have a force majeure contract in your applicable contract, and if that contract is not governed by Indian law. So once you step outside the national arena into the international arena, you can't necessarily rely on that certificate being recognized for all purposes. So, as any lawyer would say, it all depends on the facts and the contracts. So, but we are in extraordinary times, and I think governments have to help out local industries by calling force majeure or the equivalent, because that is what is happening. I think in the short term, we're not seeing lots of disputes about force majeure at the moment. We're seeing people just scrambling around, trying to understand what their obligations are and trying to renegotiate, hoping that this is all a short-term crisis. And by that, I mean something which will last for a few months. And then it depends on the nature of the contract. If the contract is a long-term arrangement, a few months is only a few months, and you would be expected to mitigate your losses, and not for that event to be an event which terminates the contract or would result in frustration of the contract, as Jyoti was talking about. So I hope, well, that's the best I can say at the moment, Alice.
I think with that, I would like to close this session. Thanks to all the panelists who took time off and attended this webinar to give their insights. Thank you to all of you. Thank you to all the attendees as well for giving us your valuable time, for joining this webinar. And as always, CMS and CAM remain available to answer any further questions you may have. Thank you, everybody.